We are going to return, and I'm going to give the introduction again. Our next speaker is the Honorable Lloyd Budzinski. Judge Budzinski served as a Crown Attorney, Defense Counsel, Assistant Deputy Minister of Criminal Law, and Judge with the Ontario Court of Justice. He has over 50 years of trial experience. Judge Budzinski has taught across Ontario and currently trains lawyers, investigators, probation officers, teachers, and students on advocacy, basic and advanced evidence, reliable testimony, and bias. He's already given one presentation today to this audience, and that presentation was on evidence and legal investigations. He's currently going to be talking to us about how judges assess truth. And in this presentation, he's going to look at psychology as it relates to bias and relationship building. So I will turn it over to the Honorable Lloyd Budzinski. Your Honor. You're muted right now. You're still muted.
Okay. How do I get my face there? Do you want my face on there? Or do you want me
your face is on.
Oh, it's on. Okay. So you see me, okay? And you hear me, right?
Yep, you're good.
Okay. Well, I'm going to just digress a little bit from what I was speaking, because as I've heard all the speakers and the questions, I take it there's a mixed audience of both security workers and security managers who are operating firms or high up in firms. And I question this. Why don't, I mean, there's a lot of us retired judges sitting around doing nothing and would be happy to collect just not a lot of money, just enough to declare it as an expense on income tax. That's all. So there's a lot of lawyers, retired lawyers, who talk and love to educate, and it's really not a high cost. And so I don't know why some of the professions, the firms, get together and form an association where they set sort of standards, like an exam or a short course, where all their members take that course and they can say, this is a course or a set of standards that we've created for people in our industry. And that becomes sort of a sort of an identifier of gold standards in the profession. So there's a lot of people you can outreach to, and then people are frightened to talk to judges because, you know, they live in ivory towers and, you know, people just don't talk to judges. But the retired ones love to talk. And you find that the higher you get in any profession, the more you like to talk about yourself. So there's a lot of available information out there that you can all draw on. There's other people like me. I do it on the basis I want to improve civil understanding or community understanding of the justice system. And so I'm interested in increasing the professionalism of policing and security work above and beyond what the average person has or knows. There seems to me, you know, a career path for security people, many security people, who can't get into a police force right away, but join security work and eventually try to work into a police force. And there's nothing wrong with that. If hiring people who are prepared to give 5 years or 6 years of dedicated work for you to get training and experience so they can become a police officer, and it's regarded as a higher profession. There's an agency, several agencies in Canada are trying to create a community of a college of policing where police officers are licensed before they can practice as a police officer. So, you know, what I'm doing is inviting your audience here to reach out and to try different ideas. Like I say, I'm very happy to if I could find someone to do a video of some trials so that young students could watch it and write judgments and get an appreciation of what they have to produce to go to court. Even in policing today, there's with videotaping of many cases and plea bargaining, the average police officer gets very little courtroom experience. And so the level of competency in a courtroom is really fallen down, both in all fields. It's not only security work. The security officer, because he gives evidence so seldom, is the most insecure in the courtroom. He's willing to agree with anything, generally speaking, that doesn't make him have doesn't he doesn't appear in a bad light, and that's nothing wrong with that. That's what people are like, and until you get the evidence, giving evidence, and being experienced and knowing your limitations, you'll always have that insecurity. I tell witnesses, lay witnesses, when they're testifying, is look at the judge, and before, if you think it's a wrong question, that ask the judge, may you answer that question? You know, the typical question is, this goes to evidence, is that your workers or your investigators and police officers generally aren't allowed to give opinion evidence because they're not expert. Expert opinion evidence is only admissible for experts, or only allowable for experts. However, there's a whole series of questions that are based on human experience, everyday experience. For example, how old is the person up here? Well, that's an opinion question, and you can answer that. Did that person appear upset? That's a question of emotional state of mind. Although that's an opinion question, it can be answered by a lay witness. If you're asking about the speed of a car, that's an opinion question that can be answered by a lay witness. Reasonable probable grounds. Did you have grounds to do the arrest? That's an opinion question. So just basic, and this is not taught in any school or university. This is what I'm trying to get across to people. Simple instruction based on how the average person reacts to situations is so critical. So in asking an opinion, for example, did the person appear upset? Or even identity is an opinion question. Is that the same person? We forget that it's asking for an opinion which has to be based on objectivity. And I've already dealt on objectivity. And to teach people what objectivity is, you got to go to the scientific literature and understand that objectivity is giving both sides, articulating why you accept certain pieces of information over the other and how you came to your opinion, and then to show that you then try to disprove your opinion to show that there's no alternative explanation for what you have concluded. That's something that's taught in grade 12 high school, and you can draw upon that prior education with your students who are taking security courses, or your trainees, or your experienced people. It's interesting because when you're asked your opinion, it's really a conclusion, and like I say, the conclusion has to be objective. So I told you the story about isn't it possible that, and you don't have to agree that anything's possible. You can give both sides of the story and why you accepted some and disregarded some and came to your conclusion. The trick, or the technique to teach your investigators, is that they have to sort of analyze their own thoughts. So if you're asking a question, how fast he was going, then you have to say how you came to that conclusion. Well, you can say I was going 60 miles an hour and he passed me and he seemed to double his length every minute. And, you say that he was doubling his speed. He was going 120 miles an hour. Or you're passing lampposts at a faster rate than ever before. Or if you're giving the identity of a person. If you say the person looks like someone, what are you really saying? Are you saying, I think he looks like some, my opinion, but what's your opinion based on? Well, the opinion is usually based on characteristics, hair color, eye color, facial shape. It's then based also on configuration. So not only characteristics, but there's another aspect to describing it, is configuration, the positioning of the eyes, how wide the nose is, how the chin, how the chin is located, what distance from the nose. Those are what AI uses to identify people. But a good witness can break it down into those elements. So teaching a basic concept that much of your evidence is opinion evidence, And this is how you formulate opinions. It's got nothing to do with the rule of law or got nothing to do with the rules of evidence. It's just got to do with psychology and how you describe things. And I guess that's where I'm a little bit of I have a novel approach here because I take it away from the rules of life. And I take it to, again, looking at yourself, analyzing your thoughts. It's like a physicist, and that's my background. You have to break the event down to its essential pieces of activity. It's smaller elements to come to the describing the event. And that's something you do by demonstration and you do by talking about people and how they think. So, would a university start invoking that into a teaching course? Maybe. Would a community college? Maybe. Or maybe you could, in the sense of creating a more well-rounded investigator and creating a reputation that your firm has this type of criteria for its students and employees that can gain you market share. So I can't speak for the business. You guys are all more experienced in it than I am. I'm not a business person. But academically, there's resources out there to do that. It just needs 3 or 4 firms, 3 or 4 people to, and even Roy, it's even you could do this, is form an association that has this accredited type of a course, and then advertise it. Like I say, that this agency for creating a agency for a college of policing is something that's well worth looking into for all your members because it affects you indirectly. If they are becoming professional, a true profession, then you want to sort of catch on to that and do the same thing. A profession is not just experience. A profession is designed by a set of standards. And why that's important, because in policing, we have the blue line, officers protecting each other's backs. You have that in your field too. One security person will try to protect the back of another. What you have to establish is that it's not a team effort. That's what the Gouge inquiry was. The policing or expert evidence isn't a team effort. It's an individual effort owed to the organization or the profession in which you belong. So creating a true profession for security people, I guess, has double-edged sword. It means that you're going to have higher demands for income from those people who have taken these courses, and you'll have a higher standard of hiring. But in today's world, I'm not sure that's a negative. But we can talk about that anytime you want, and we can go back to that. So I've talked about what I'm talking about is how I would lecture on evidence, and one of the questions that people have to understand is relevancy. That's the threshold question. Does it make an act more probable or less probable? It's not. So admissibility of evidence is based on whether it advances the theory of the case more probably or less probable, but it has to be relevant to advancing the case. It's not certainty. It's simply a factor of probability. So those are little evidentiary rules which, if understood correctly by the young student, by the young trainee, they take it into the work. Now, once they walk into the work situation, what you need is highly trained senior people to help them transfer their academic knowledge into street knowledge. And that's a problem in policing. We're losing a lot of senior officers, so you have junior midstream officers teaching young officers how to deal with matters, and they don't have the years of experience, that mellowness, that concept of empathy, that we're not winners or losers. One of the things you want to teach investigators is you're not a winner or loser. You're there to objectively record the truth and produce the truth in front of the lawyer who argues the case in front of the judge. That all you are is, I'm not demeaning the profession, but to be a good investigator, you're sort of an objective person who can assess all the evidence that's available. And this is the type of lectures I see being more important than what the rules are. Now, I open myself to the other experts there, other people in the field, to question me or challenge me. What I say is never meant to be gospel truth. It's just meant to be my ideas subject to challenges. I always surrounded myself with workers that would challenge my ideas and not sort of agree with me. I found out that it was more, unlike Trump, I found it was more valuable to have people that disagreed with me work for me than those that agreed with everything I said. Now, if you're going back home and you want to teach your investigators two simple rules, this is where it becomes important, okay? And the first word is loved. I learned this in a course for newly elected district attorneys in Texas, where I had the benefit of going for a month when I was a Crown attorney. And loved are key letters for key words. So every person to prove their case has to understand loved. Loved means you've got to indicate the location of the offense to get jurisdiction. So you got to testify without being asked, where did the offense occur, in what jurisdiction? The second part of loved is you got to give the offense, the details of the offense, the things that constitute the offense. The lipstick was in her pocket and she passed the cash register without paying. That's theft, okay? So you got to be able to explain the offense, the elements of that offense. Venue, that's to get legal jurisdiction. The offense occurred in the city of Toronto or municipality appeal or the region appeal or whatever. So that's venue. So loved location of the offense in the Bay Store, located in the plaza in Peel. That's now the loved is the location and now the venue. And now you got to talk about the offense itself. The next thing that makes all evidence relevant, this is what every officer should know and have in their notebook, is identity. And the person I saw take that candy is that person sitting there in the witness stand. How many times that's been lost by young crowns or lost by police officers because they talk about him, and they never point the him being the accused in the witness stand. So that's fundamental. So identity. And then, of course, the date of the offense, when it occurred. You can't have offenses occurring, years before or months before. You want to say this occurred on the 5th day of June at such and such a location. So loved is what you want every darn investigator to have in their notebooks to understand that, okay? Keeping notes are important, okay? Recording those notes in your own words is important. Using bullet points is important. If it's missing, admit that it's missing in your notes. You didn't record it. Don't try to hide the fact, but your notes, the need for detailed notes is critical. Now, there's another key set of words of what do you record? What's the relevant evidence? What evidence is admissible, is probative? Probative evidence is that evidence which advances the theory, okay? Makes the theory more probable than not. So the other code word you want, every person should know it in a standard test, is the terms MOMS, M-O-M-M-S. M stands for motive. Critical. You don't have to always have motive to convict someone of a criminal offense, but you do need motive to amplify the acts that you saw that were unlawful, the explanation why it happened. So motive is not a necessary element of an offense, but an essential piece of evidence to collect, okay? The other thing is opportunity. The accused says, I was with my mother watching television when the event took place. Well, you got to give evidence that the accused was in a situation or position where he could be there. Well, the security guard pointing to him and saying, that's the man who I saw take the candy. That's simple. But in a circumstantial case where the guy got away and you arrest him later based on other information, and his mom says, no, he wasn't at the store, he was with me, That's opportunity. You got to prove that, okay? And going back to motive, when you're dealing with the motive of the person doing the crime, that's important. But the motive of every witness who testifies is also important. Because if a mother is giving alibi for her son, evidence for her son, and you know it's the mother, okay, giving alibi, the question you'd want the Crown to ask is, do you love your son? So the relationship between the accused and the person providing the motive, providing the alibi, is important to be able to distinguish the reliability of that witness's evidence in supporting the motive. So motive is important both for the total case and also for each individual witness. I can't say anything more than motive is critical. If you've got to find that for every witness you have, if you want to do a detailed and proper investigation. The question to ask a mother, like I said, is who's giving a motive for her son is as a Crown attorney, the best question you can ask is, do you love your son? And there I explain the rationale of cross-examination. The question is the media, and people have to understand that. It's not the answer. You're not trying to break a witness down, unless you want to make him angry and then you introduce, like I say, a point of view into his evidence. But the motive is, every month, if she answers yes to that question, you've advanced your case. In other words, you haven't broken the witness, you've advanced the case. Do you love your son? Everyone knows that a person who loves their son would lie for their son, likely. But if the next question was, but if she answered not under oath, I would, because I'm a very religious woman, she's neutralized the question. Because that's a real, not an impossible answer. So the judge is evaluating your question from your answer. So for witnesses, investigators to understand that mechanism, they'd understand what questioning is all about in cross-examination, and allows them to answer the questions with more integrity. Now, if the mother had answered, I love my son, I wouldn't lie under oath, and you asked back, and you can't in law, even if it was facing the death penalty, and now you've upped it, and if she says, no, I'd still follow my faith, now you got a situation where the judge is saying, yeah, it could be true, but maybe not. So now he's back seeing the witnesses being maybe a little bit of a fibber or unreliable, not lying, but being biased. So understanding bias and how that works and putting your case together is very important.
2 minutes.
The last question is method, the means and method. Did they have a gun to commit the murder? Was the murder done by a shot or a stabbing or whatever? And lastly is supportive evidence. That evidence, when I spoke about the cup of coffee earlier in the wife abuse case, is really important because it sets the reality of the explanation given by any witness in the total circumstances of the case. And most importantly, it gives me, the judge, the ability to articulate why I believe a witness. So the supportive evidence that supports or takes away from a particular witness's point of view is very important. So all your investigators should be taught love it and moms. That's if they know that, then they know the evidence to collect, and that's simple. At least once you understand that. Okay. Okay, let's go to questions. Okay, I've sort of changed my final speech a little bit to deal with the nature of the questions that were coming. Does anyone have questions on any of this?
I open the floor to questions. If you just want to turn on your microphone and ask, I will comment though that. Go ahead. Go ahead.
Yeah, go ahead.
Hi. Yeah. Thanks. A lot of information. There's a lot more involved as a security guard and a security company, and when you get into trying to convict, I have a question in regards to an honest answer as a judge. Where should we be concentrating as a security company when we're already challenged in the system where police let us know it's pretty rare to get a conviction even on their own if everything has been compiled, and that's on an RCMP or a police level. They're having a hard time with conviction as catch and release. Do you think we should be, as a security company or companies, moving into a different direction, or should we be working towards more of what the RCMP are doing?
Well, you remember, the judge is objective, okay? The judge has to follow the law. So you want to be seen as an objective association and not necessarily seeking a conviction, but seeking truth. Now, we can get into a large political dialogue about public misunderstanding of the law, and what a lot of more junior police officers don't understand. So let's take example, minimal sentences, okay? The federal government passes a law saying we're going to make this a serious crime by having a minimal sentence applied here. Well, that's what the feds say, and they write the law, okay? But who enforces that law? The province, right? So if you have minimal sentences, people don't want to plead guilty. They will go to trial because they got nothing to lose, because most often they'll only get the minimal sentence, okay? Well, if people go to trial, what happens to your trial dockets? They get crowded. If they get crowded, you have trial delay. If I have an accused who has to sit in jail for 2 years to wait his trial, or release him under tight conditions, what do you think my choices are? I'm really obliged to release them because the charter, and rightfully so, shows that we have a right to an early trial. So I release him, but I make very strict conditions that the police have to knock on his door every night, that he's got to report every so often. His mother's got to post $200,000 bail, and he can't leave the house without her, okay? So what happens? He breaches the rules. Why? Because the police didn't have the resources to knock on his door every night. So the police are sort of trying to blame someone else because they don't have the proper funding to achieve the purposes that's allotted to the province. And it's really a fair law. Right now, there's a reverse onus for arrest and release, that if a person has a prior record, they have to justify their custody, their release. So we're playing a lot of head games here, which is really financial and resource-based. The truckers in Ottawa, the big strike there, well, everyone says, oh, geez, the federal government asking for these ridiculous penalties, okay? So what happens? It wasn't the federal government that prosecuted these people. The jurisdiction belongs to the province. They did the prosecution. They were asking for the ridiculous sentences. It was Ford asking for it, not Trudeau. So there's this game that we play with misconceptions that we could spend hours talking about. But, you know, it's like in Peel, when the first diversion projects were started, the stores actually, once they found out about diversion, they started to like it because it provided the person had to follow certain things, it provided for restitution, and it made their job simpler and cheaper. But, you know, this is a political issue that it depends on how you want it. If you want all your guy, every time your guy stops someone, arrested and charged and convicted, that takes one thing. But that then makes your client, the Bay, look like the big bad guys. They don't look at you. They look at the Bay and what the policy of the Bay. If the Bay is understanding in some circumstances, the mother's unemployed, the mother's got cancer, there's psychiatric issues there. Okay, she's sorry and she's never done this before. She'll pay that back. The Bay will be looked at as a reasonable citizen. So a lot of this is mental game playing that the politicians are using us all for. All I know is that minimal sentences have not decreased crime. Okay, there's other ways to decrease crime. And it's cheaper to have a diversion project in shoplifting cases, for example, than to go to trial in every case, because it means your guy has to wait in court for a number of days or weeks or whatever, and has to go through a whole bunch of stuff that cost you money when he could be out in the store keeping watch. But you disagree with me, challenge me on that. Go ahead, Joseph. Are you there? Have I chased you away?
No, I just had to grab my phone.
Oh, okay.
Yeah, most of your answer was once again thorough,
Right.
but I still struggle with, we're a smaller company and
Right.
probably no different than any other security company trying to grow, trying to give our employees the right kind of training and move it to a
Right.
higher level, which is, I think, the industry's goal. Is there something that you would suggest as a judge we concentrate on first for our guards? Is it compiling evidence and becoming a good investigator, or is it more just policing and observing?
Well, you know, if you want to reduce crime, you know what the statistics say. It's not the degree of penalty; it's the risk of getting caught. That's what we assess when we do it. When you're driving down the road and you decide to speed, you're assessing whether or not you're going to get caught or not, right? So apprehension. So both are valuable. You reduce the crime just by your presence there. Like the Walmart person having someone. I mean, it pisses me off. Sorry, but it bugs me when people. I'm asked, produce my bill and all that sort of stuff as I leave the store. However, it's tolerable. I accept it. And it does reduce, I suspect it does reduce crime because the risk of jumping by them with some extra stuff is reduced. Catching the bad guy, unless it's a major crime, how much, it's publicity that deters the person from doing the crime. And if the trial happens 6 months after, a year or two after, and this is the reason why we oppose delayed trials, it doesn't affect the public. I mean, a young kid who gets in trouble at school, right? The deterrent effect of a sentence is only as good as that school term. Because once that term's over, and if the trial hasn't been heard, everyone else says, oh, John was caught shoplifting. But they don't know what happens to John after because they're all gone. So the need for early trials has the effect of being a deterrent. And that's why I blame a lot of the provinces for not wanting to put the money into that asset. The one thing I'll finish off, Joe, is that if every answer you have, there's no such thing as a perfect answer. It's like aspirin. It has a good side and a bad side. And you have to assess both sides and find out what's more realistic and what's better. So you can't write the perfect. You want to write a perfect law that every shoplifter is caught, apprehended, and convicted? You make him prove his guilt, his innocence. But we won't tolerate that as a society. That's how we judge. And yeah, I got an interesting story about juries if you want to hear. But I'll take questions before I go into that.
Yeah. Are there any other questions? I know there was a couple of people that talked at the same time.
Anyone?
All right, then we'll have your question and then we'll move on to the next speaker, okay? Your Honor?
Okay. Yep. Okay, so no questions, right? Let me give you this quick story about how jury trials came to be. Reasonable doubt. Before reasonable doubt, we would have trial by burning or trial by drowning or trial by whatever you want to call it, okay? And the theory there was that God would determine guilt or innocence. So if they put a stone around you and put you in the river and you drowned, God said you're guilty. If you floated to the surface, people would believe God saved you. So around the 15th century, we started to lose faith in God, and we started to have juries. Now, juries, if you look at 19 Deuteronomy in the Bible, bearing false witness, it's not an eye for an eye. It's if you lie about someone and they face a penalty because of that, you are deserving of the same penalty that they received, okay? That's false witness. So it's not an eye for an eye. And so what happened is juries were frightened that if they made a mistake, they'd be punished to hell because they were bearing false witness. So to get around that, the courts came up, or the government came up, well, you don't have to be absolutely certain. If you're convinced beyond a reasonable doubt and you convict him, you won't go to hell because you didn't bear false witness. And that's the story of how reasonable doubt came to be. That's the story. Okay.
That's impressive.
Thank you.
That's good. Well, Your Honor, thank you very much for another very, very interesting presentation. I appreciate your time and coming to this. And if other people, I do have His Honor's contact information. If anyone wants to get a hold of him, please contact CASP, and we will put you in contact if you want to have presentations for your groups and the like. He's very open to doing things like that.
Okay, and because I'm retired, I can say things I couldn't say as a judge. So thank you, guys. Really appreciate the opportunity.
All right. Thank you again, Your Honor.
Bye.